Proceed with the case. We're the conservators of the resource, and the state is not in this case. The only case that's really relied on by the Attorney General is the old 2-inch rule case, which went to an ALJ.
Proceed. The hearing officer in paragraph 55 of the order, back on the rule challenge, said, quote, "No dangerous level of unnecessary killing or waste will occur, and the rule will enhance the overall fish population recovery effect."
I'd like to ask you one question. Go ahead.
Does the 2-inch net gill or capture, I'm not a fisherman, 90% of illegal fish?
Thought you could slip one over on me, didn't you, eh?
When they ran those tests,
when they ran the tests,
yeah, what happened?
I don't know the exact numbers, Your Honor, but that doesn't sound out of line. 90% of the fish that were gilled.
That's what Mr. Maurer just
said.
I'm
not questioning his that. I mean, 90% of the fish that were gilled were juvenile.
Oh, is that what I stepped in? I wondered what it was.
So it was the considered opinion of the commission that allowing the use of the 2-inch net is not going to hurt this population, and that's exactly what the uncontested statistics show.
Now you tell me what you know.
It is not economically reasonable for a fisherman to go out there and whack the undersized fish. They're not going to do that.
Oh, sometimes I think I must go mad. Where will it all end? What is it getting you?
First of all, we're dealing with the rational basis test here. We have a constitutionally created agency, and the appellants don't argue with the fact that we have to use the rational basis test.
Oh, very observant. Thank you. You're welcome.
The agency's judgment that gilling, number one, would not have an adverse effect on the population as a whole.
Did you ever go to school, stupid? Yes, sir. And I come out the same way.
A conclusion made by the hearing officer in 1997 and borne out by the data, undisputed data.
7 to 8? Once. Now I'm going to carry the 7 from here and put it under the 8. 7 from 8? 1. A minute ago, I didn't use that level 2.
What are you going to do?
I got to use that 2 now. I'm going to take it from there, and I'm going to put it right there. Now, 7 to 21?
3 times.
That's correct. 7 to 28, 13.
A conclusion made by the hearing officer in 1997 and borne out by the data, undisputed data, today.
7 to 28, 13.
90% of the fish that were gilled were juvenile. The rule will enhance the overall fish population recovery effect.
You are warm, and so is she. But don't be discouraged. With a little study, you'll go a long ways, and I wish you'd start now.
Those tests, the information that was gleaned from those tests was exactly what the agency expected.
Pretty tricky when you don't know it, isn't it, eh?
They knew that the 3-inch net would gill legal-sized fish, and they knew that the 2-inch net was going to gill undersized fish.
Isn't that against the law?
And in the exercise of their judgment, they determined, based on the historical use of nets, based on the advice of their experts, that the 2-inch mesh rule would be a reasonable place to draw the line.
I'm getting the idea, but I didn't get it for a long time, you know.
And secondly, Your Honor, it's based on a misconception. The rule does not require the use of a 2-inch net. 2 inches is the maximum. If they're gilling undersized fish and making it uneconomical for fishermen to use a 2-inch net, they can reconfigure their net. They can use smaller mesh size. As we say in our brief, in Texas, they limit them to 1 inch. Not 2 inch, but 1 inch.
Did you ever go to school, stupid? Yes, sir. And I come out the same way.
90% of the fish that were gilled were juvenile. If the agency presents a rational basis for the rule on the record, then that's all they have to do.
There's a whole lot of things you don't know.
This is a debatable question about the reasonableness of the Commission's decision. And it's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination. This has been litigated. It was litigated in 1997.
Or let me ask you right there, has it ever been litigated that the 2-inch mesh net is illegal, as they're saying today? Has it ever been litigated in that respect?
Well,
you know darn well it's so.
What was litigated was whether the choice of 2 inches was reasonable and not arbitrary and capricious. And in the exercise of their judgment, they determined that the 2-inch net was going to gill undersized fish. It is not economically reasonable for a fisherman to go out there and whack the undersized fish. They're not going to do that. They knew that the 2-inch net was going to gill undersized fish.
I think you've got something there. I'll wait outside until you clean it up.
Well, let me ask you this, Counselor. Can your commission just do anything and we have no supervision over it, even if it's totally unreasonable?
Let's have some action around here. Who'll say 76? Who'll say 1776? That's the spirit, 1776.
Why shouldn't it be considered when you get better data, and newer data, and as I understand, your client agreed with the appellant to go out and test these nets, and when the results appeared to be adverse to your client's position, then the tests were terminated. Is that a...
That is not, absolutely not what happened, Your Honor.
You're a contemptible cur. I repeat, sir, you're a contemptible cur. Oh, if I were a man, you'd resent that.
It is a question here where we draw the line in the courts as to whether a rational basis is presented or not.
If the agency presents a rational basis for the rule on the record, then that's all they have to do.
I'll get it in a minute, though, won't I?
This is a debatable question about the reasonableness of the Commission's decision. And it's not for the court to debate the wisdom of the legislative determination, or in this case, quasi-legislative determination.
That's the spirit, 1776.
The plaintiffs in that case, Your Honor, made exactly the same claim that they're making here. Paragraph 65, the hearing officer says, petitioners challenge the proposed rule because it will allegedly cause unnecessary killing, overfishing, and waste of juvenile fish. That is exactly what they're saying today, and she discounted that. She said that's not correct.
Now you tell me what you know.
They knew that the 2-inch net was going to gill undersized fish. It is not economically reasonable for a fisherman to go out there and whack the undersized fish. They're not going to do that. The selection of 2 inches in paragraph 76 was historically based, rational, and practical.
Well, let me stop you right there, because I want to make a point. 90% were juvenile fish, which we say were illegal. You couldn't take them, couldn't harvest them. All right, what percentage did the 3-inch net do to accomplish? What percentage did they get?
Forgive me, Your Honor, I don't know. It's about, what was it, 70% or something were legal.
Well, you should have asked me. I didn't know it.
And in the exercise of their judgment, they determined, based on the historical use of nets, based on the advice of their experts, that the 2-inch mesh rule would be a reasonable place to draw the line. They knew that the 3-inch net would gill legal-sized fish, and they knew that the 2-inch net was going to gill undersized fish. It makes no economic sense to go out there with a 2-inch mesh net and do that to the juvenile fish.
Now, just a moment. Wait a minute. He might be crazy. Wait, I'll find out.
That is a debatable question of reasonableness, which is up to the agency to determine, not for the court.
Fine. Oh, yeah. Any questions? Any answers?
I'm John Blogow on behalf of the Fish and Wildlife Commission.
I didn't know you were a lawyer. You're awfully shy for a lawyer.
You bet I'm shy. I'm a shy lawyer. There's the door leading out, and I wish you'd use it.
Thank you.